To talk more about those graft charges as well as what's at stake in this Malampaya deal, we are joined this morning by Attorney Rico Domingo. He is the lawyer of the complainants before the Office of the Ombudsman, and he is also the president of the Philippine Bar Association. Good morning, Attorney Domingo. Thank you for joining us.
Good morning, Mike. Good morning, Nikki. And good morning to the viewers and the listeners of your program.
First off, Attorney Domingo, what has happened to the complaint your clients filed before the Ombudsman last month? Any development?
There's no later development. It was filed on October 18 by the complainant himself, Mr. Palgamel de Belen Domingo. In this particular context, I'd like to tell the viewers and the listeners that I'm not in any way related to the complainant. The other complainants would be Mrs. Loida Nicolas, and the other one is another lawyer from the States, Rodel Rodis.
All right. Now, Attorney Domingo, let's take a step back and situate our discussion on the Malampaya deals. How significant is the Malampaya gas field to our country's energy supply?
It's very, very significant. In fact, it is imbued with national interest. If you recall, it was actually pursuant to the Presidential Decree number 87, and there's a service contract in 1990 that was signed by the previous President Aquino. And that was in answer to the energy crisis. No? Remember that Malampaya project actually supplies 40% of the country's sources, energy sources. It supplies about 37 to 40% of the Luzon electrical sources as well. So this is very important. If this is actually pursued, I mean, if they go to the conclusion that they will be taking over, then there'll be a lot of problems, a lot of crises going on. And this is actually owned by the Philippine government. This is owned by the Philippine state. This is not a private contract. This is a contract between the Philippine government and the original contractors, Chevron and Shell. This cannot be relegated to simply a personal or corporate transaction, Mike and Nikki.
Now, Attorney Domingo, your complaint claims Energy Secretary Alfonso Cusi and other respondents gave unwarranted benefits and advantage to Dennis Ui's Udenna Corporation in the sale of shares, Chevron share, and transfer of rights in the Malampaya project. Well, that's because Udenna's subsidiary, UC Malampaya, supposedly did not have the financial and technical expertise to bid for the project. Explain to us why this is, and how did it manage to obtain approval from the DOE if that's the case?
Well, the last question may be posed to Mr. Cusi, the respondent. But the first phase of your question would be, you just look at the Senate minutes of the Senate of the chairman Sherwin Gatchalian's committee, the Committee on Energy. Mr. Gatchalian did a very good job conducting a hearing, a very thorough, comprehensive hearing on November 10, 2020, July 14, 2020, and 28 September 2020. All of our findings, as well as our private research, would indicate all the allegations and averments in the criminal complaint had been proven by testimony of resource persons at the Senate proceedings.
Talk about the Senate proceedings. Senator Sherwin Gatchalian has pointed out that the DOE actually evaluated not UC Malampaya's financial, technical, and legal capability, but that of UC 38. This is the resulting entity after UC Malampaya acquired Chevron shares. So he's saying this raised questions if UC Malampaya itself is qualified. Now, your complaint said UC Malampaya bought Chevron's share in April 2019, but it was incorporated only in September 2019. So how anomalous is this for you?
Well, it's basic in corporate transactions that if you are going to enter into a contract, you have to be qualified. Considering that UC Malampaya said that it's qualified, then it could have been a corporate entity by that time. At that time, there was no registration with the SEC, which is very fundamental. Then they would not have any standing to contract with another party, much less the original contractor, Chevron.
And let's talk about the technical capability of UC Malampaya. Does it have the track record to run, say, the Malampaya project?
Again, during the Senate hearings, it was even admitted that the Malampaya, the Udenna, doesn't have any other contract of similar nature. In fact, they don't have any international exposure. In other words, it was admitted that they did not have the technical know-how on this. It was admitted. Please read the minutes, which are all attached to the criminal complaint. We're not really fabricating anything here. We have all the facts of the case. And I, with all due respect to the president that you had just quoted earlier and interviewed, we have all the facts, and all the facts are given in the Senate minutes, the minutes of the Senate Energy Committee meeting or meetings, the 3 meetings. All of them are there. We're not fabricating anything.
There's a claim, Attorney Domingo, that anyway, some of the former employees of Shell or Chevron are now with Udenna's subsidiaries. Is this enough, though, having the people?
That's precisely the problem, because you cannot say that the successor corporate entity, in this particular case, the UC Malampaya, eventually renamed UC 38, would have the technical and financial wherewithals for this. It cannot be said along that line, because there's a complete change of management, complete change of directorship, complete change of them. Practically 90% of Malampaya project had already been transferred. Now, you cannot say that because people had been there before through Chevron or through Shell, it cannot be said that way. They don't have the technical, financial, and legal standings for this, as they had vetted with the original contractors, Chevron, Shell. They don't have that right now. In fact, there was even an admission during the Senate committee hearings that they don't have any project of similar nature. How can they say now that they have the experience and the wherewithals for that?
Now, Attorney Domingo, for our audience, let's just point out that Chevron shares accounted for 45% of Malampaya project. The other 45% is controlled by Shell, but Udenna's other subsidiary, Malampaya Energy, has bought this, but the DOE has yet to approve that. So just to complete the picture, the remaining 10% is controlled by PNOC. So effectively, we will control 90% of the Malampaya project if both transactions push through. How alarming is this for you?
Very alarming, because this is against the law. The law is Presidential Decree number 87 in Section 11, and there is an analogous or practically the same provision in Section 16.4 of the service contract that we're talking about, Service Contract 38. That was where the entire deal was struck. Then, what
does it say?
It says that the rights and obligations of the contractor, meaning Chevron and Shell, under this contract shall not be assigned or transferred without the prior approval of the DOE. And according to Senate proceedings and Senate minutes of the Senate committee hearings, there was no prior approval. Now, let me tell you, Mike and Nikki, they are trying to say that it is a private transaction, okay? It's just merely an exchange of shares, a transfer of shares. But they have to be reminded, in particular the Senate, they have to be reminded that under Article 1306 of the new Civil Code, the contractors in any contract, meaning contract, as what we are talking about right now, cannot stipulate, they cannot even put any clauses or terms that would be violative of the existing law. And the law here is what? Presidential Decree number 87, and of course the corresponding provision in the section of the service contract. That is the law. You cannot disregard that. You cannot relegate it to a simple contract between contracting parties. No, please. This is a contract that is imbued with interest and therefore should follow the ironclad safety measures provided by PD 87 and the service contract. In fact, there was even no showing that the government, which has the right to match, did so. And yet it was capable of doing that because it could have taken over the Chevron interests without any cost on itself. So you can see really some circumstances may have evolved or intervened that would have already pushed the 90% interest to be sold to that party.
And Attorney Domingo, you talked about that right of the Philippine government to exercise its right of first refusal. It could have matched Udenna's offer, but it did not. Instead, you said in the complaint, it stands to lose between 21 billion to 42 billion pesos a year. How did you arrive at this computation?
There is a very intricate computation given by our financial consultant along that line. You can just read the provisions and the averments in the contract. It is lucidly presented there. But our bottom line is that the Philippines, the Filipino people, would stand to lose about 42 billion pesos because of this outright sale. But that's not the end of it, Mike and Nikki. The end of it is that we have estimated that the total losses during the entire duration of this contract, which would be until January 2024, or even in the interim, would be about 138 billion pesos. Translated to foreign currency, it's about 2.75 billion. We're talking about that. We can even use that for pandemic alleviation, for the program of the government, for the purchase of the masks, the purchase of the PPE. All of this should have been done and used for those purposes. What about the frontliners? The nurses have not been paid up to now. Okay, people are losing jobs. They don't have a job. We have to have some economic recovery along this line. And that 138 billion would have used for those purposes. Now we have spiraling gasoline. Nikki and araw-araw, meron tayong tumataas ang ating gasolina. For the past 10 weeks, our gasoline prices have really spiraled. We could use that as a subsidy to the Filipino people. And we're not using that because only one company, one group is benefiting from all these things. That is the national interest here, Mike and Nikki. That is what we're talking about.
Attorney Domingo, you mentioned about the profitability because yesterday the Energy Department, through Assistant Secretary Gerardo Erguiza Jr., they issued a press release saying the PNOC took into account economic and risk factors in deciding not to match Udenna's offer. He also pointed out that Shell could have matched Udenna's offer in the Chevron shares, but did not, and in fact decided to sell its shares as well. So does this really mean it's not profitable for the PNOC to enter into this contract, taking over the Malampaya project? And why was Udenna interested? I mean, the existing wells are supposedly to be depleted by 2027.
As to the statement attributed to the Secretary Cusi, with all due respect to him, there are admissions during the Senate meetings that he himself said that it is a very good investment. It is a good investment for the Philippine government. He said that. He was minuted. It was registered in the Senate hearings. And he said that there was a sudden turnaround. So, in other words, the Philippine government should have taken over without any further investment over that. In any event, if they wanted to really put forward the $565 million that have been paid allegedly to Chevron, they could have sourced it from Philippine banks, the Development Bank of the Philippines, the Land Bank, on very, very good terms. They could have done that because at the end of the day, in January 2024, the Philippine government would own the entire service contract. And the Philippine can... Another alternative would be privatization, what they did with the water concessions. The government could have privatized it at very good terms. They did not do that. In other words, all the conditions and circumstances will show that the taking over of the Chevron 45% eventually and Shell 45% interest in service contract would have been taken over by the Philippine government, the Filipino people, the Filipino future generations, Mike and Nikki. And they did not, according to the complaint, they did not do that. That's why it is now under the legal lens of the Anti-Corrupt and Practices Act. That is what the complainants said in their criminal complaint.
Attorney Domingo, just on that point, would it have been wise for the government to enter the picture? Because some have pointed out the Philippine government isn't necessarily known for its efficiency, and we need the capital and the technology of foreign entities.
But there are existing operations right now. This is not a greenfield operation. It is actually a brownfield operation in the context of the industry. In other words, it's an ongoing thing. It's profiting. Just gaining all this profits should have been given to the Philippine government if it has taken over. And they have technical people on the fields. They have them. They're all there, provided they are given the proper terms and conditions for their staying there. In fact, we know now through our investigation privately that because of this takeover, there are some people who are leaving the site, and that is known. So
are there concerns about sustainability of the operations? Should the takeover
I cannot say that. That's not within the purview of the criminal complaint. But certainly there are news about that. I cannot confirm that, but as of now, there are news about people leaving the site because of whatever reason. I cannot attribute that to any reason.
One other question, Attorney Domingo. Why did Chevron and Shell leave? Senator Gatchalian had pointed out that Shell, as early as 2016, actually wanted to extend the service contract of the Malampaya project beyond 2024. But there was no action on that. But when Udenna's Malampaya Energy entered the picture, negotiations suddenly picked up pace. So to what extent was the expiration of the service contract in 2024 a factor in Chevron and Shell's decision to leave? Because Udenna's president, Mr. Escalona, said it was to reduce their upstream footprint and to focus on a few geographies. What's your assessment?
The assessment is that why would Chevron and Shell ask for extension if they do not know that there is a very profitable anticipation of profitable business and revenues? Okay, that was in 2016. In fact, the research shows that the Malampaya project can still be extended for another 10 years. So they knew and they anticipated as very astute corporate entities, meaning Chevron and Shell. They knew it was a profitable concern. Now, one of the press releases later on, when they were talking about TIR during the Senate hearing, the DOE was quoted as saying they are not extending the contract beyond 2024. And as you said, and I'm not saying that here right now, but you said there are reports, the reason why that is the case, and afterwards, Udenna or the new company had said that in April 2019, it has struck a deal with the Chevron Philippines. In fact, the Chevron Philippines, its mother corporation in the States, had provided the details with the Federal Securities and Exchange Commission and said they consummated that deal in March 2020.
Now, lastly, just to close this discussion, Attorney Domingo, why should Filipinos closely monitor developments in this issue?
The Filipino people should be vigilant about this, Mike and Nikki. It is, as I mentioned several times, this is of national interest. This is for the future generations of Filipinos. Now, I can see that you can cry about this, but you can cry about corporate revenues for one particular corporation. But we should cry for the Filipino people. We should cry for the future generations. Mga apo mo, Mike, mga anak mo, Nikki, mga apo mo, ito ay dapat nating gawing bagay na we should monitor this. And we cannot allow this. We have to stand up and be counted here. This is dwarfing what is involved in the Farmally case. Malaki ito. We're talking about 138 billion here. So dapat pakinggan, bigyan tayong vigilante tayo dito, pakinggan natin. And I ask all the Filipino people who are listening right now to join us. To join the patriotic Mr. Domingo, who's not related to me. Now, you can put some political underpinnings here and the involvement of Mrs. Loida Nicolas Lewis. You can put a political color here, but she is a patriotic person. This is not about politics. This is about graft and corruption, Nikki and Mike. This is about graft and corruption. We're not talking about politics here. This is not a partisan activity. This is for the Filipino people and its future generations.
One final question, Attorney Domingo. Are there concerns of interference of or involvement of foreign interest here, considering the ties of Dennis Uy with Chinese corporations?
Well, I'm not making that implication because that's beyond the criminal complaint. But there are some people who are saying that Malampaya project is just nearby, although it's within the economic zone of the Philippines, very close to the Palawan coastal area. They are saying that you can just use the 500-kilometer pipeline that connects the Malampaya project site and the Batangas plants. You can connect them. That's about 500 kilometers. That's about the distance between Manila and Baguio. You can connect that and use that because you have already 90% of that. The pipelines, the wells, and the other structures worth about 4.5 billion US dollars that the Filipino people had invested in that particular project. That is what we're talking about right now.
All right. Thank you so much for talking to us and sharing your insights with us this morning, Attorney Rico Domingo.
Thank you, Mike, and thank you, Nikki, and thank you, everyone.